It is now.
Okay, wonderful. All right, well, welcome everyone. First, some logistics. Following Sarah's overview, we will have 20 to 30 minutes for questions. Please use the Q&A feature here in the Zoom window to submit questions for Sarah. Please use the chat box for general discussion, saying hello, or requesting technical assistance. Questions for Sarah submitted in the chat may not be seen or answered, so please be sure to put those in the Q&A. And again, we will take questions at the end of Sarah's overview. You can upvote a submitted question if the question is also of interest to you. We'll attempt to answer as many questions as possible. However, if we're unable to answer all submitted questions, we may be able to provide some responses via email following the webinar. This webinar is being recorded, and the recording link will be available after the webinar is completed. Before we get started, I'd like to introduce the Fire Networks to those who may be less familiar with our team. The Fire Networks partnership invests in people and place-based efforts to change relationships with fire, helping foster shared responsibility for fire management and viable fire cultures and landscapes and communities across the country. We work through 3 interconnected peer networks. I'm trying to get my slide to advance here. The Fire Learning Network, the Fire Adapted Communities Learning Network, and the Indigenous Peoples Burning Network. And it just failed. All right, let me get that started again here. All right, it is not going to cooperate with me.
You might try going backwards. I think you're on the last slide rather than the first one.
Ah, thank you,
There you go.
Autumn.
Yeah.
Woo, all right, here we go. These are the 4 internet connected networks: the Fire Learning Network, the Fire Adapted Communities Learning Network, and the Indigenous Peoples Burning Network, and the Prescribed Fire Training Exchanges. These support local, regional, and national action that improves fire outcomes in the near term and for generations to come. The fire networks support practitioners and conduct work from coast to coast in the United States. In many areas, multiple networks are engaged, providing complementary approaches to address fire challenges and opportunities. Engagement from partners in other countries has continued to expand our reach internationally, especially through prescribed fire training exchanges, TREX and WTREX, sharing approaches to community adaptation and expanding governance models for integrated fire management. Please visit our website at firenetworks.org to learn more. You'll also find information on how to sign up for our email newsletter, The Networker, and how to receive the Fire Networks blog, where we feature stories and information from a diversity of perspectives related to community wildfire resilience. And I'm Emily Homan. I'm director of the Fire Learning Network. We also have Laurel Kays, our FLN manager, and Autumn Jugstad. Sorry, Autumn, I always get your name wrong. Autumn is our executive coordinator for the team. We're here to support you today through this webinar. And now I'll introduce Sara. Sara, if you want to start your screen share. Sara, thank you so much for joining us today and providing your insights on prescribed fire liability. Sara Clark is a partner at the public interest law firm Shute, Mihaly, and Weinberger LLP, based in San Francisco, California. Sara has worked extensively on prescribed fire liability, including an instrumental role in passage of California's legislation defining gross negligence for suppression costs and establishment of the Prescribed Fire Claims Fund pilot. She was a co-author of the Good Fire Report for the Karuk Tribe, an analysis of barriers to the expansion of cultural burning and recommended solutions. Watch for Good Fire 2 coming this month. Sara is licensed to practice in the state of California. Please keep in mind that some state-specific questions may need to be addressed by a local attorney. So now we're going to have just a really quick poll so we can understand where people are located today, and then we'll dive in. Give you just a couple minutes to complete that quick poll. It looks like responses are slowing. Just give you a few more seconds to click through that. So I'm going to go ahead and close the poll. We'll share our results. Looks like a great mix of people.
Great. Should I get started, Emily?
Yeah, let's do it, Sarah. Thanks.
Great. What an interesting result. So many more public agency folks here, which is great. I will touch on that. So nice to be with you all this morning. As Emily introduced me, I'm Sara Clark. I've been working in this space for about the past 7 or 8 years. And I will give you just a little bit more of my background. So this work for me started by assisting prescribed burn associations, tribes, nonprofits, and local agencies in the actual implementation of prescribed fire and cultural burning projects. Primarily, folks came to me with questions around liability and insurance and how cooperative groups could work together. From there, that grew into working in the policy space and really trying to address a number of the barriers that my clients were seeing. And so in that particular effort, I've been involved in a number of things across state and federal policy and really feel really grateful to do that work. So we have a good fire report, which I did for the Karuk Tribe. And as Emily said, we are working on version 2. It's in the design phase right now. That's really focused more on federal policy. So look out for that if you're interested in cultural burning issues. Worked on a number of bills at the California State Legislature, which I'll get into in a little bit. And then I've been involved in 2 major reports. One served as the lead facilitator for California's strategic plan for expanding the use of beneficial fire, which came out in March 2022, and really helped to set the course for California and how all the various different agencies, practitioners, et cetera, are working together. And then finally, this last year, I've served as a subject matter expert on the Biden-Harris Wildland Fire Mitigation and Management Commission. That report came out in September and is driving a lot of further conversations on the Hill about what we can do at the federal level. So very glad to be with you today. I do want to provide just one more caveat, which is that because this is an informational webinar format, this does not constitute legal advice, and it does not create or imply an attorney-client relationship with me or my firm, and that liability laws are state-specific, and the information that I'm going to talk about today may not apply in the exact way I talk about it in your jurisdiction or your specific situation. So take this as an educational or informational webinar, and if you have specific questions that I may be able to help with, we can be in touch after. So what are we going to do together today? I am going to first talk through how liability works in general and help get us grounded in a conversation about what prescribed fire practitioners can expect in the liability sphere, to get us all on the same page about what the different terminology means and where you can expect to see potential risks, as well as the most common strategies to help mitigate those risks. And then I'm going to spend a chunk of time talking through the really significant changes in this space that have happened in California, beginning in 2018, but really accelerating over the last 3 years. And the intent of sharing this story is to hopefully provide a little bit of inspiration, guidance, best practices, and lessons learned about how we have worked through these changes in California for you to bring to your own states if you live elsewhere, or if you're in California, to get you a little bit more acquainted with what some of the changes do and do not do, because I know there's confusion in this area of law can be complicated. The next, I'm going to focus a little bit on some of the other changes that are happening in other states across the country, so you can see the flavor of work that is being done. And then finally, I'm going to close out with a couple minutes, maybe 5 or 10 minutes, on some of the other work that I do that's not liability related, just because there are intersecting questions. And I wanted to provide that overview, and then if folks have questions about them, I can get into them in greater detail. So that is the plan for today. To start with the liability overview. So I always start by reminding folks that the best way to address liability is to ensure that things don't go wrong in the first place. This is where investments in training and planning and resources are always worth it. I am not the person to help you figure that out. That is what the Fire Learning Network and TREX and a variety of other sources are there to help make sure that prescribed fire practitioners are adequately trained, have the resources they need. But that is by far the best investment that you can make, is to make sure that our fires are being done safely. However, we know that in this space, folks are always concerned about what implications and risks they face if things might go wrong. And so what I've outlined here on the screen are really the three primary ways that prescribed fire practitioners can potentially incur costs associated with their burns that are unexpected. And note that what I'm going to do here first is talk about the potential route for liability, meaning the types of costs you could be exposed to. Next, in the next slide, I'm going to talk about the standards that apply. And these two things get intermixed in ways that can be a little bit complicated. So I'm going to start with the buckets. We're then going to talk about the standards, and then we're going to talk about how they intersect. So the first primary way that prescribed burn practitioners can incur unexpected costs or risks associated with a fire is for participant liability. This is what happens if someone on your burn gets injured, someone breaks a leg or twists an ankle or has a mishap with a chainsaw. So that covers both personal injury, and hopefully this does not occur, but death as well. This also can cover property damage. So a couple of common examples are if you have harm to equipment, either PPE or other sort of more significant equipment that gets damaged on the site. The other common damage that you can see is if you are a landowner, you're a participant in the burn in that way, you may have unexpected consequences to your property because you set your burn perimeter, and then if it inadvertently escapes and burns down your own barn, that is an unexpected cost that you are incurring, and that the other participants in the burn may have liability for. So that's the first bucket, is all the harms that could come to the people that are actively participating or showing up or intending to be at the burn. The second bucket is the thing that we most commonly think of in this category, which is third-party liability. So this is exposure to risk related to your burn causing harm to a third party, someone that was not involved in the burn, that didn't sign up to be there, and that is sort of an innocent bystander. Typically, we think of property damage as the main type of third-party liability. Your burn escapes, and it burns down your neighbor's house. Obviously, that is a pretty significant consequence with potential risk and liability associated with it. This category can also include personal injury. So if your burn escapes and it causes harm, this could be to a first responder, this could be to a neighbor, this could be to someone that is driving down an adjacent roadway and has smoke exposure that causes them to get into a car accident. So those are all potential pathways for personal injury to third parties. The smoke question can bring up a whole other category of potential third-party damages as well. So in addition to those automobile crashes, which there's a number of published case laws from around the country where that has been a potential harm that has resulted. The thing that has come up a lot in California recently is smoke taint. So smoke taint is where grapes are on the vine or growing and are exposed to smoke. That can cause damage to the wine crop, making the products either less valuable or in some extreme circumstances, they can't be sold at all. And so this is another potential route for third-party liability where a prescribed fire causes smoke taint and damages that grape crop. The last thing that falls into third-party liability that sometimes comes up is harm to natural resources or timber damage. So if you have a prescribed fire that burns into an adjacent area and causes natural resource harm that can be documented, you could be potentially liable for that. or if you burn down a valuable timber crop, that's another potential place where you see damages. So that's the second bucket, second thing you could incur potential costs or risks for. The last one is suppression or investigation costs. So this bucket is really about the costs to the government related to an escaped fire. So this is the cost for the government for sending out a backup tanker or a crew, or sending out a full suite of suppression resources if that's what's needed. This often also includes the cost of sending out an investigation team after the fact to determine what happened, why suppression resources were needed, and who should be liable. So at the end of the day, in most states, the party that responded, whether that's your state agency or a local fire district or a federal agency, could send you, the prescribed burner, a bill for suppression and investigation costs. And here in California, that is certainly a category where we've seen a number of prescribed burners receive bills after the fact. So it's a potential risk in a way that may not be anticipated or expected. And I'm going to talk a little bit later about the perverse incentives that creates, and how that we use that to our advantage in California. So those are the buckets, the types of things you could be liable for. What I'm going to talk about next is what the standards are. So for each of those buckets, you need to know the circumstances in which the prescribed fire practitioner would be liable for the associated harm. Just because your burn causes a harm does not necessarily mean that you are responsible for paying that person for the damage. And that standard is known as the liability standard, or the standard of care that is owed. This map, I will say, is old. It's from 2016. It's the most recent one I could find online in a quick search. So don't look at your state and say, oh, well, I am in a simple negligence state, because I know that there have been changes since this map was made. But I'm putting it up here because I wanted you all to see that what the liability standards are for prescribed fire varies as across each state. So some states are gross negligence, some are strict liability, some are undefined. And I'm going to talk about what those standards are, but know that wherever you are located, there's going to be a different state law that applies to set the standard for what the duty of care is with respect to prescribed fire. Okay, so what are the different standards that we might see? First, I just want to note that what constitutes negligence is often not prescribed fire specific. It's a definition that applies across all of what is called tort law. That's a funny word, T-O-R-T, but essentially it means the body of law that governs the harms that humans can cause to each other and when people are responsible for paying for that. Your precise definition of what constitutes negligence will be decided either by your court system, by your legislature through statute, or as in the case of California, it can be both, where the legislature and the courts kind of have a dance back and forth, where courts decide something, legislature writes it down, sometimes the courts will modify it, legislature will modify it. But in general, the basic understanding of what strict liability, simple negligence, and gross negligence are don't vary too much state to state. The reason for that is that these standards are based in what's called common law. It comes over from England. There's a body of law that we base our whole foundation on for hundreds of years. And so our tort standards are quite similar across the board for prescribed fire and for other types of torts. So what are the potential standards that might apply? First, we have strict liability. This is considered sort of the worst standard for the prescribed fire community. And as you can see on the previous slide, if you took a close look at it, relatively few states have this, but it still comes into play. So what strict liability means is if you cause the harm, you are liable, no matter how careful you were, no matter what precautions you took, no matter what freak accident happened to cause the escape or the damage. In many instances in this world, causation might be obvious. You start the fire takes a very clear path and then burns down your neighboring house. The causation there is going to be pretty clear. So if you're in a strict liability state, proving that you are liable is going to be fairly easy. In some other instances, causation is going to be harder to prove. So for instance, the grape taint example that I gave, it is not at all clear how the grapes were affected by smoke, especially if you have some prescribed fire smoke and some wildfire smoke occurring at different times during the growing season. And so causation in that context may be more difficult to prove. So even in a strict liability state, the party that is harmed still needs to prove causation in order to establish that they're entitled to payment from the prescribed burner. The second standard that I want to talk about is simple negligence. This is the most common standard. And generally speaking, if your state has not established a standard by statute, your courts will have established a simple negligence standard as sort of a background principle. So you can think of simple negligence as the general default if there's no clear guidance on the issue. So what is a simple negligence standard? And I know we had a question from before, from the sign up about like, how do you explain what simple negligence is? So I'm going to attempt to do that for you right now. So first off, just to start, you still have to prove causation. So in order to be liable under simple negligence, you still have to cross that hurdle we talked about. The next part of it is that you have to show that what the burner did was not what a reasonably prudent person under same or similar circumstances would have done. So that's a lot of words, but essentially what the courts do in this circumstance is they attempt to create a fictional, reasonably prudent person under the circumstances who desired to comply with the law. So there's a fact-finding effort to figure out what are the best practices across the ground in this state. What would most people do in this circumstance if they had this wind reading, if they had this relative humidity reading, if they knew this topography? What do the laws require that person to do? And did you comply? So once you have that reasonably prudent person set up and established, then you compare what you did to that reasonably prudent person. So if you did the same as that reasonably prudent person, then you are not liable, even if you caused the harm. Similarly, if you performed better than the reasonably prudent person, but there was still some sort of harm that was caused, you again should not be liable. The thing that is important to note here is that under simple negligence, this is what lawyers call a very fact-dependent inquiry. And essentially what that means is that this is going to be really hard for the court to figure out, because not only do they have to look at what is the causation, they have to figure out what is this reasonably prudent person. This is going to require experts and other practitioners to come in and explain what should have been done in this circumstance. Then they also have to do the inquiry into what did you do? What was the specific things that happened that potentially went wrong the day of the burn? And the reason why I bring this up is that when you have a fact-dependent inquiry, it's going to be a lot of time and effort for you to defend, even if at the end of the day, you would be found not liable. And what this means is that it's generally beneficial for the parties that were harmed to file a lawsuit against you and to force you to defend and then hopefully settle for something. So that's what plaintiffs or the parties that are harmed are hoping for in a simple negligence state, is that they can at least file that initial lawsuit. You bear the brunt of figuring out, oh my, this is going to be so much for me to defend myself. I'd rather pay them off and not have to deal with it. And so the simple negligence standard for that reason creates these incentives wherein prescribed fire practitioners are not necessarily fully protected, even if at the end of the day, they could establish that they had exercised due diligence. So that's the simple negligence standard. The next negligence standard, and the one that is quote unquote best for prescribed fires, is the gross negligence standard. And gross negligence, again, you still have to prove causation. So you still have to go through that establishment of, did the burn cause the harm? But then there are a couple of different framings of the gross negligence standard across the board. But generally, the party hoping to recover must prove that the prescribed burner was reckless, that there was no care or common sense displayed with respect to the fire. This is hard to prove because most of us do a lot of things to show that we are giving good care, good common sense. We get our permits, we write a burn plan, we have backup contingency resources. So even if something goes wrong, or even if you had one or two things that you could have done better, it's going to be very hard for a petitioner to prove that you showed no care or common sense, even the slightest degree of common sense or diligence. So the gross negligence standard is considered much more protective of the prescribed burning community, and conversely, much less protective of those who are potentially harmed. I do want to mention the pie in the sky idea that no state has adopted, but something to think about and something to potentially talk about, is that across the board, a number of states have adopted what are called immunity statutes in circumstances that I think are arguably analogous. So the most common one is called a recreational immunity statute. And what that says, it's kind of the converse of the strict liability, is basically that the party doing the thing is never liable. And that because there is a public interest in doing this thing, we should reward them or incentivize them to do that activity. The recreational immunity statutes are all about private landowners opening their lands for public access. Most states have a statute that says if someone is injured while hiking on those private lands, then there is no recourse for them to turn around and sue the landowner. So I raise this only because I think it can be like a potentially good talking point, and to really explain that when something has a public benefit or public purpose, like prescribed fire, then there are instances where the state uses their liability standards to try and incentivize that behavior. I think it's probably unlikely that we ever get there in state law, although maybe I'll challenge all of you to try. So those are the standards that I wanted to talk about. So remember, we had our buckets of the potential, I'm gonna go back, sorry, of the things you could be liable for. And then here on screen, we have all of the standards that might apply. And what you need to know is that states can pick and choose which standards apply to each of the buckets that we talked about. So where California has now gone is that in general, we have a simple negligence standard for those first two buckets for participant and third-party damages, but we have a gross negligence standard for suppression costs. South Carolina has taken also a similar sort of hybrid approach where they have a simple negligence standards for most things, but a gross negligence standard for third-party damages or participant damages related to smoke. And so in this way, the liability standards, I think, are a little bit more complicated than just saying the state that I live in is a, quote, simple negligence state or a strict liability state. Because there are different things that you can be liable for, you need to really understand which liability standard applies to each of those things. And I want to note too, at this point, that, and in response to some questions we received, that these standards often intersect with some other issues. And I'm going to we'll talk a little bit more about certification programs later on, but someone asked about kind of the benefits of certification programs and how they intersect with the standards that might apply. So what the other reason why this gets more complicated than just saying we have a simple negligence state is that in some states, Washington is a good example, it's simple negligence, except if you have a burn boss certification program and the person complies with that, then we move to a gross negligence standard. So again, it's this mix of multiple standards that apply based on whether you meet certain criteria or you're talking about specific things. The standards also, someone asked about how they sort of intersect with right to burn laws. Right to burn laws, as I generally understand them, are intended more around the permitting process and how much oversight a state has for whether a party can automatically burn on their land. Essentially, a right to burn law is akin to saying, like, this is an inherent property right that I have to manage my land in this way. Most of the time, when you have a right to burn law, it doesn't necessarily change what the liability standard is. So you might have a right to burn, but you still would be potentially liable under your state's negligence framework if your burn escaped. So a couple of other common questions that come up. Under these liability standards, is everyone in the burn liable? And I would say that as a default, you should assume that the answer is potentially yes. Basically anyone that is on the property or the property owner has the potential to be held liable if there is an escape. However, courts will do a fact-specific inquiry to see which participants did or did not meet the relevant standard. And in general, the more involved in decision-making you are, the more likely you're going to be the party that is held liable if anyone is held liable. If multiple people are negligent, then typically what happens is the courts apply what's called joint and several liability, meaning that until the damage is paid, everyone is still on the hook for it. In some instances, they will apportion and say, like, the burn boss is responsible for 70% of the damage and the landowner is responsible for 30% of the damage. We'll talk a little bit more later about how the parties might adjust those percentages. I also wanted to note here that there is always the potential for vicarious liability, which is, it applies when a party hires someone who then does something negligent. So in this context, it could be that the landowner has hired a burn boss and didn't do a very good job of checking that person's credentials. The landowner might be vicariously liable for that hiring. Likewise, if you have an organization that is, excuse me, involved in the hiring of a burn boss or the burn planning or whatever, and they have an employee that is mainly driving those decision-making processes, then the employer is likely vicariously liable for what the employee did, so long as it's within the scope of the employment. Again, these are kind of basic principles. The fact-specific, like what the court would actually do, depends on the circumstances, but note that those are the principles that the courts would look to. So just wanted to note briefly here, and we'll talk about it more later, that through what are called indemnification agreements, some participants in a burn might assume the liability of other parties. And that can change whether one party is liable or not. And then finally, sort of just a practical tip is that most of the time, if a third party is harmed by an escaped prescribed fire, they are going to look to what's called deep pockets. So this will likely be bigger organizations that are involved in a burn, wealthy landowners, or agencies, because those plaintiffs want to make sure that they're going to get paid if they can establish that there was someone liable. So if you are part of one of those types of organizations, it's really important to make sure that you understand what your risks are, knowing that potential plaintiffs are going to look to you. The other question that we got in this context is, well, what about federal lands, federal employees, state employees, local employees, tribes? Like, how does the government apply these rules? And again, going back to the poll, I know we have a lot of government employees on here. So to start, federal entities and employees are protected by what's called the Federal Tort Claims Act, FTCA. And what the Federal Tort Claims Act does is, as a background principle, government agencies retain what's called sovereign immunity from suit. So essentially what this means is that you cannot sue the government for the harm that it caused you unless the government let you. And the federal government has let the public sue it by passing something called the Federal Tort Claims Act. And that lays out the specific ways that the public could sue a federal entity if the federal entity was responsible for the escaped prescribed fire. This Federal Tort Claims Act establishes that the agency is responsible for payment if it's within the scope of their employees. So generally speaking, federal employees are protected by the FTCA from being individually liable for things that they did, unless they did something so outside the bounds that it would be found not part of their employment. And then what the FTCA does, and why it relates back to everything we've been talking about, is the FTCA says that the federal government will pay the claim if a private party would be liable for that claim under state law. So the federal government essentially imports the relevant state standard to determine whether or not they're going to pay the claim for what their federal employees have done. There is a huge caveat, though, because the FTCA does not pay claims for discretionary activities. And discretionary activities are ones where you exercise your judgment to determine what to do. In many prescribed fire cases, that exercise of discretion may mean that the claim is not recoverable. So I bring up the Federal Tort Claims Act because most states have done a copycat of it and essentially have a state equivalent of the Federal Tort Claims Act that establishes the same standards. So if you're a state employee or a subdivision of the state, meaning a local government, you most likely have something similar to the Federal Tort Claims Act in place, which indicates that the federal or the government entity should pay if you have something go wrong while on the job. And it will set out the process by which the harmed party can potentially recover from that entity. And again, in most instances, this applies the relevant state standards that we were just talking about. With tribes, it is somewhat tricky. So when tribes are engaged in prescribed fire activities, and I'm saying that as distinct from cultural burning, if they're engaged in prescribed fire activities that are governed by the BIA, the Bureau of Indian Affairs regulations, or if they're engaged in prescribed fire activities under a 638 self-governance compact, then typically the FTCA will apply to the tribe in the same way it would apply to a federal employee. When tribes are doing burning that is outside of those particular things, essentially when tribes are burning outside of the scope of activities expressly sanctioned by the federal government, then their potential exposure to tort liability is much more unclear. Although I will note that tribes are also generally immune from suit under the principles of sovereign immunity. Whether their employees are is a separate matter. So putting a pin in that one because it's complicated. So some of the ways that burners can potentially address this liability, no matter what standard applies, I'm going to go through a couple of these potential options, and I'm going to advance my slides. So we're going to talk about waivers and indemnity and insurance coverage. So waivers, this really is talking about that first bucket of potential harms that we discussed, that participant damages. So this is, again, that risk that you face if someone on your burn gets injured or has property damage. A waiver is a legal tool that expressly says that a participant gives up the right to sue the other participants or landowners if they come onto the property. So the general principle here is that if someone is coming to the burn, then they assume the risk that something will go wrong, and they agree not to sue their fellow participants for that potential damage. Usually these will create a carve out if there's gross negligence or willful misconduct. Again, obviously, if someone is on the burn and starts behaving, erratically or inappropriately, you want to make sure that the waiver doesn't inadvertently prevent you from recovering from that person. But waivers are an effective way of addressing this first category. You need to have good systems in place to make sure you get all signatures, which I know can be hard when you are out in the field. Worked with a number of clients on systems for that. I will also note that you will often have a hard time getting agency employees willing to sign a waiver if they're coming out to like a nonprofit or tribal-led burn. And having long conversations with the agencies to try and get their employees to sign. So that's a little caveat there. We got a question from the group about whether waivers are enforceable. And generally speaking, yes, waivers are enforceable so long as the party knew what they were agreeing to before they signed up. There's certainly been cases where if you have like, you know, those huge pages of like endless waivers, the party doesn't really know what the risk is. They just sign it before they go in to like, you know, a bounce house or something, that those waivers may not be as enforceable as you would like. But in a context where you are providing adequate information about the potential risks and the party really seems informed, then a waiver should hold up in court. I will also note, however, that a waiver does not prevent you from being sued. So it's a way of getting rid of a claim before, you know, something it's adverse to you, but it doesn't necessarily prevent there being a lawsuit filed and the potential for settlement negotiations. So that's first item is waivers. And I'll say that for every group that I work with, generally we get waivers in place and recommend strongly that you get as many participants signing those as possible. Next way that you can potentially address liability issues is through indemnifications provisions. And I know that for most non-lawyers, you're just like, oh, that section of the agreement that says waivers and indemnifications is like 4 pages long and has so much legalese, and I don't understand what it means. Just to separate it out for you, waiver is giving up your right to sue other people. Indemnification is agreeing to defend someone else that is sued. So they're often like shoved together, but they're 2 distinct acts. So why indemnification comes up in this circumstance is that it is the mechanism by which one participant in the burn asks another participant in the burn to be primarily responsible if something goes wrong. So a common one is if I'm the landowner and I hire a burn boss, I might ask that burn boss to indemnify me if their burn causes third-party damages. And that way, if something goes wrong, then the burn boss is on the hook to pay those. However, indemnification only goes so far as the indemnifying party has assets sufficient to cover the loss. So you need to understand if someone has agreed to indemnify you, do they have sufficient assets? Ideally, do they have insurance? And what is the potential limit of those? Because if they run out, then I would still be on the hook. You cannot use indemnification to prevent the harm party from recovering. You can only use it to determine the order that must be paid. So some scenarios where someone asked, there are scenarios where the burn boss has insurance, but subcontractors or volunteers do not. Is it okay to conduct the burn with a waiver? And this is a place where I wanted to clarify what you want in that instance where the burn boss has insurance and then other parties do not. A waiver is good, but that only addresses the participant damages. What you really want is an indemnification where that burn boss agrees to cover the subs and volunteers. Okay, and then on insurance, just to cover this somewhat briefly, insurance is covered through general liability or loggers broad form insurance are the most typical types of insurance that may be available for this. Some other potential insurance that could come into play is workers' compensation. So if someone's injured on a burn, workers' comp can cover it. A number of local agencies have what's called self-insurance or a joint pool insurance where they, it's essentially insurance, but the structure to pay for it is a little bit different. That might cover things. Automobile insurance might cover things if you have an accident. Crop insurance might cover things if you end up burning or affecting grapes or timber resources. So those are the scope of insurance products that are available. Things that you want to check to make sure it's doing what you want is does the insurance cover the activity in question? And are there any limitations on its use? I have had clients that have read their general commercial liability insurance and said, well, it just doesn't say anything at all about prescribed fire. Doesn't that mean I am covered? And I can understand the hesitation of wanting to ask because of the worry that they may say no. And my general recommendation, however, is it's best to ask, because when push comes to shove, if you think you have insurance and you're planning on relying on it, you need to know it's really solid and really there. You also need to know how much you're covered for. And you need to make sure that that insurance coverage covers participant damages, third-party damages, and potentially suppression or investigation costs, which it may or may not do. And then finally, if you're relying on someone else's insurance, you want to make sure you ask, are you an additional insured on that person's insurance? Being an additional insured is just like one paperwork burden that you remove. If the insurance company knows that they're going to cover you, makes it easier if something goes wrong. And then finally, I know there's been a couple of questions about criminal liability is there criminal liability in this context? So the answer is yes, there is criminal liability on the books. However, I have not seen, and I am not aware of any stories of prosecutors attempting to use criminal liability against prescribed buyers where we have sort of run-of-the-mill routine things go wrong. You can see it where it looks like someone is saying that it's prescribed fire when really there was arson or some really extreme circumstance. The other time you've seen criminal liability come up is where it is convenient for someone's political narrative around the arrest that happened in Oregon last year. So yes, it's out there, but in general, haven't seen a huge amount of criminal liability, which is good. Okay, I'm next going to go into talking about California's story. And I'm going to attempt to do this sort of quickly, and then we can get into more questions at the end if people have them. So as I said up top, California has had sort of a transformational change in this space since 2018. So in 2018, we had a minor tweak to our liability standard. It sort of set the stage for this conversation. I'll share that language with you in a moment. Then in 2020, we set up our state certified burn boss program, which created a state pathway to recognize the experience of burn bosses. And right now, it's been a little slow to get certified burn bosses, but right now I believe we have 32 at last count. So we're getting there, but we're a big state and we have a lot of burning to do. In 2021, when the state was flush with cash, the Nature Conservancy spearheaded an effort to get $20 million of that budget set aside for establishment of a prescribed fire claims fund. Also that year, we were able to pass a law, which I'll get into in a moment, called SB 332, related to creating a gross negligence standard for those suppression and investigation costs. Then in 2023, we actually got that claims fund set up. And in 2024, we're now working on some agreements to acknowledge tribal sovereignty in this context. So as you can see, it has been just every year marching through and trying to tick off one item on the list. And that really has been an effort of the prescribed burn community in the state, being pretty tactical about the things that we have asked for and really working with a broad coalition to get this done. So I want to talk about a couple of the specifics in here. So SB 1260, which is that first one, is just the addition of this language at the end. Compliance with a permit issued pursuant to this article, i.e. a burn permit, shall constitute prima facie evidence of due diligence. So this, if we go back to when I was talking about what the simple negligence standard is and how you have to create that reasonable person that you compare things to, what this law says is that compliance with your permit is that reasonable person. And so it shortcuts one of the fact inquiries in a simple negligence standard, ideally to make it easier for a prescribed burner to both know what is going to be reasonable and then to show that they were reasonable. We haven't seen this actually be applied yet, so unclear how it will work in court. But that was that first little change. And for those of you that are in states where you're not quite getting traction on gross negligence, you might think about something like this. Okay, then the next big change was SB 332. This was our attempt to get a gross negligence standard across the board: participant damages, third-party damages, and suppression costs. However, when the bill was introduced, we almost immediately got pushback from the plaintiff's bar, essentially the attorneys that bring lawsuits for tort damages across the state. And it wasn't because I don't like prescribed fire, it's just they don't want to see anything that makes it harder for them to win lawsuits. And so they're a major Democratic contributor, and we got told basically as soon as their opposition came in that we were not going to be able to run that bill in that format that year. So we pivoted and we thought to ourselves, okay, well, if we can't address, if what they're really concerned about is being able to sue for third-party damages, could we still do something around suppression and investigation costs? And again, you might remember I said that in California, the suppression and investigation costs, people were getting bills for those. It was one of the things that people were most concerned about. And the reason for that is because if you have a problem, you want to call for backup. You don't want to wait and say, oh, maybe I'll get this under control and I won't face that liability. So it was creating this perverse incentive where it discouraged people from actually picking up the phone, calling for backup help, and hopefully getting something under control in short order. And that was a story that we were really able to help tell as to why this was necessary and why for public purpose burning, it makes sense that our public services are the ones that are on the hook to help out. So that's what we pivoted to. SB 332 was drafted. We largely used language that was similar to what Florida had done for the gross negligence standard by setting out sort of criteria, which you'll see here in 1 through 6. And I'll just flag briefly. So criteria are pretty obvious. It has to be for public purpose burning. You have to have a burn boss, not on site, but a burn boss has to review your plan. So we tried to make it a little bit less onerous, knowing a lot of landowners don't necessarily want to hire a burn boss to run the burn, and we have a shortage. 3 is that you are conducted in compliance with the written prescription. So if you write that plan, you have to comply. 4, you have to get your burn permit if a burn permit is required. 5, you have to get the landowner's written permission. 6, you need an air quality permit. And then 7 is this is the place where we attempted to create a different pathway for cultural fire practitioners. So cultural fire practitioners do not need to have a burn boss review their plan because indeed they do not need a written plan at all. The thing that we wished we had done in SB 332 but just couldn't make happen was address the appearance of imposing state regulatory laws on cultural burns. So cultural burners arguably still must get burn permits and air quality permits under this section. And that is, I'll tell you in a second what we're working on in that regard. So here you can see the definitions for cultural burn and cultural fire practitioner. And section C is the part of this law that makes the gross negligence standard operable. So essentially, if you comply with all those terms, then no fire suppression or investigation costs unless it's grossly negligent. So that is how California handled the suppression and investigations costs. How we handled the third-party damages, which we left on the table in that round, is through that set aside for the claims fund and then a bill called SB 926, which became law basically a year ago now. And SB 926 set up California's Prescribed Fire Claims Fund pilot program, which has $20 million available to pay most third-party damages if you meet certain requirements. And again, in this one, we had been pushing to have the same requirements as SB 332. Our state fire agency did not like that, and we now have more requirements. But essentially, in this instance, to be eligible for the claim fund, You have to use a burn boss to supervise, unless you're a cultural fire practitioner. And you have to have them review a burn plan in advance. But if you do, then you're eligible for up to $2 million in potential losses that are automatically covered once the state determines that there was causation and that there was loss. No one has to prove a liability standard here. And then the last thing, let me just go back one real quick. So also in SB 926, you'll see that a burn permit is again required and all other permits are required. So we've left open this question of, do cultural fire practitioners need to get permits? The way we are hoping to solve that is we have a bill called SB 310, which is currently pending, which would create a pathway for sovereign to sovereign agreements between tribes and the state that essentially confirm that there's tribal sovereignty with respect to cultural burning and that no state permits are required. So fingers crossed, we're going to get that done this year and then hopefully start to get agreements into place. So what else is happening? So I wanted to cover just some of the changes that are happening across the board. South Carolina was one of, well, Florida, Michigan, Nevada, all did stuff quite a while ago. In sort of the last 10 years, some of the interesting stuff coming out is South Carolina in 2012 adopted a gross negligence standard, but again, only with respect to liability caused by the resulting smoke of a prescribed fire. And there was a very large coalition, which I'm 99% certain include the Nature Conservancy as well, working on getting that passed. In Oregon, this is more recently, we've had some efforts to try and establish a similar prescribed fire claims fund, although to California, although not quite successful yet. 2021, there was an effort to direct a study to examine the affordability and accessibility of insurance to sort of make the case for why a prescribed fire claims fund would be needed. And the findings from that study are in line with what we've seen before. There's a low incidence of escape. Insurance is very expensive or unavailable. And that changing the liability standard alone is unlikely to bring insurers back into the market. There was a run at trying to set up a prescribed fire pilot program in 2023, but that did not quite make it out of committee. Happy if anyone else has other Oregon-specific anecdotes to share that I might have missed. That really goes for any of these states. If I missed something or misstate something, please correct me. New Mexico had a more successful play here, and in 2019, similarly to Oregon, they created a working group to study the barriers to expanding prescribed burning on private lands. And then in 2021, they passed the Prescribed Burning Act, which enacted many of the recommendations of that working group. And they moved from an undefined liability standard to a simple negligence standard for prescribed burning on private lands, created a training and certification program, and then created an incentive for landowners to get the training or to use people with the training by reducing the potential damage exposure. And then finally in Washington, I believe it was in 2018, that the state adopted a law requiring the Department of Natural Resources to establish a prescribed burn manager certification program. So similar to California's state certified burn boss program, and said that if you use one of those certified burn managers, then a gross negligence standard applies. And I believe that the certification program went live in 2022. And so we're now starting to see burns that work under this particular standard. I also was informed that North Carolina, like its sister state, moved to a gross negligence standard for both smoke and fire recently, and again, similar coalition effort. And then I'm aware that in Idaho, they're sort of where Oregon and New Mexico, going along that route of undertaking an evaluation of the barriers and some of the market effects that could be worked on. So that's what's going on in other states. And then my final slide I thought I would talk just very briefly about some of the other work that I am working on, and then I'll open it up for questions because I see a lot coming into the Q&A. Cultural burning and tribal sovereignty. With this audience, what I wanted to say is that I know there's so much enthusiasm right now, and there may be folks from tribes or working with tribes here today. So much enthusiasm for cultural burning, which is fantastic. And I also just have some words of caution, because I think what can happen in this space, as we sort of saw happen in California, is that when we attempt to insert cultural burning into conversations that are really driven by prescribed fire, we have the potential for unintended consequences. That can happen by inadvertently blurring the lines between cultural burning and prescribed fire, which are really distinct practices. And I view the distinction as being about which law should govern those practices. Cultural burning is rooted inherently in tribal sovereignty and in the rights of tribes and indigenous peoples to decide how they burn for themselves, whereas prescribed fire covered by federal and state law. And so because of that distinction that's rooted in sovereignty, we need to make sure that any good intended efforts to just insert cultural burning into statutory efforts don't inadvertently infringe on tribal sovereignty. And that can be somewhat complicated to do. And so just wanted to flag that for all of you. The second issue that I'm working on that I know folks are interested in is around smoke impacts, and in particular, the National Ambient Air Quality Standard for particulate matter. EPA has been working on a proposed rule to reduce the NAAQS, that's the shorthand for National Ambient Air Quality Standard, to reduce the NAAQS for PM 2.5. Word on the street is that we're going from 12 down to 9 as the annual standard. This could have significant impacts on the prescribed burning community. There's a lot of work being done both within the federal family and sort of this outside all of us as agitators to try and make sure that a change in the standard doesn't just mean that all burns are going to be shut down, but it's really complicated and there's a lot of considerations at play. I'm mildly optimistic that we'll get to a place where we have procedural ease and pathways forward, but it's really complicated. And then finally, the other last thing I'm working on still is just continuing to help collaborative prescribed fire groups navigate some of the tricky issues around partnerships, whether that's governance documents, making sure you really understand how liability and insurance works in that group context, or making sure that you have sort of set yourself up to best defend any potential claims related to an escape or harm from smoke. So continuing to work with a number of collaborations in California on those questions. And then finally, I thought I would close before we get to questions on, someone asked this lovely question. Overall, how has the possibilities for forest owners to burn changed in the last decades? And what are the trends for the near future? So from my perspective, and it's a very California perspective, but I think that we are in a really exciting time where there's a lot of possibility for change in rapid succession. I think that the public has become much more aware of the importance of prescribed fire and cultural burning and other forms of beneficial fire. And that has caused legislatures, policymakers, agency folks to really become more open to working on this issue. And so, you know, I got involved sort of right at the beginning of when this was picking up steam, but in talking to the folks that have been working on these policies for longer in California, it really felt like the wildfire seasons, particularly around 2016, 2019, 2020, created this opening. And so I think there's opportunities, especially in the state legislatures, to get things done in a way that I haven't seen before. The trends that are more problematic are just around you know, things like what the public backlash that happened after Calf Canyon Hermit's Peak in New Mexico, people's fear around prescribed fire, people's fear around wildfire managed for resource benefit. And so needing to continue to build that social license, and then figuring out this smoke issue and really trying to balance the needs to protect public health, which I know we all approach this work with a real true belief that the work we're doing is protective of public health, but that the laws that we have in place don't necessarily see it that way. And so trying to get alignment is going to be tricky. So I will wrap up there and see what questions we have. And I'm going to put up this last slide, which just has my contact information on it. So feel free to reach out, but I'm going to have Emily feed me some questions.
Awesome. Thank you so much, Sarah. That was a fantastic overview. All right, we do have a bunch of questions and we're going to try to get through some here. I'm going to start generally at the top, but I'm also going to prioritize questions that are of the broadest interest or applicability, just in the interest of time. So we'd had a couple of questions related to that term smoke taint and whether that only refers to grapes or if it can refer to other assets or crops as well.
So I am certain that it could apply to other assets or crops. I think where we are seeing it come up most forcefully is in the vintners community. So I would imagine that there are other crops, if exposed to smoke, where they would decrease in value. But I think because wine grapes, like, they're just such a large asset compared to some of our other crops. And where the taste of them matters so much, it's really the place where we see the most heightened concern.
Right. Next question, is it accurate to classify negligence per se and prima facie liability as strict liability? If they are different, how? And if they are generally the same, why differentiate?
Yeah, okay. So, negligence per se is different from strict liability. So strict liability is when if you cause the harm, you are automatically liable. So it doesn't matter what you did, just as long as the thing that you did was the cause of the harm, there's liability established. Negligence per se usually refers to if you violated the law, like meaning you didn't comply with your permit, you didn't get a permit, you didn't give adequate notice, that is typically called negligence per se. And that means that because of the violation of law, then that means that you weren't reasonable because you didn't comply with what the state required you to do. So it's different from strict liability, because if negligence per se applies, it means that there's the possibility that you could cause the harm and not be liable if you complied with all the law. So hopefully that makes sense. It's a little bit complicated. Prima facie is a term used to describe in court, based on what type of lawsuit you have, one party or the other will have the obligation to make the case first. And typically speaking, if there is a escaped fire and someone is seeking damages based on their harm, they are responsible for establishing the prima facie case. And then you get to dispute it as the defendant. So it's a little bit of a different term than strict liability. It just refers to a different area of this. So, and again, maybe that's what I know from California. Maybe your state uses those terms differently. So if you have further questions about it, happy to get into it deeper, just depending on the knowledge.
Interesting, thank you. Under a simple negligence standard, isn't there a risk that if harm occurs, a jury would jump to the conclusion that there must have been negligence?
Yes, so that is definitely part of the risk, and why a simple negligence standard is not as protective for the prescribed burn community. So the cases that I have reviewed where the simple negligence standard applies, most of them that go fully to trial, like where there is a decision, you are correct. The jury will find the burner to be negligent. However, it's not always the case. And there are cases out there under the simple negligence standard where the burner is able to establish that what they did was reasonable, and where they can put up really good expert evidence showing that there's been, full compliance with the law. It was really just a freak accident. Like, they did everything that any other reasonable person would do. But I think it all comes back to the fact that the public doesn't know a ton about prescribed fire, and thanks to many different factors has had years of smoky and years of fire safety and years of, other sort of narratives, creating the perception that fire is always risky. And I think it can be really hard for prescribed burners to overcome that. So that's why this need to either move towards gross negligence or to try and set up prescribed fire claims funds is really the better option. There was something I was going to say on prescribed fire claims funds that I didn't, and I'll just mention it here, which is that if you are looking at either moving to gross negligence or a prescribed fire claims fund, and you feel like your state has both options available to you, in many ways, I think setting up a claims fund is a better option, because under a gross negligence standard, you're then asking another individual to bear the risk of something that is beneficial for everyone, right? If you burn down your neighbor's house and it's a gross negligence standard and you don't have to pay for it, and they don't have insurance coverage, or their insurance coverage is inadequate, then they're the ones that are bearing that huge risk of this activity. Whereas under a claims fund model, we're asking the public at large to share that risk. And because prescribed fire is beneficial to the public, we believe that's where at least in California, that's where we've landed, is trying to have that be a shared risk, where people who are harmed are fully compensated, but the burner is not also the one holding the bag.
So this question came in as you were talking about the claims fund, so I'll ask it now. Would the claims fund also support the cost of a lawsuit, or just the costs if you were found negligent?
So the claims fund works, the way we set it up is that hopefully a lawsuit and a determination of negligence never happens. So essentially, as long as there's causation shown, i.e. your burn caused the harm, the claims fund should pay. And once they pay, you don't have to go through a court system. You don't have to go through a determination of whether there was negligence or not. It's just an automatic payment. So that's, again, how we set it up. Whether it will work in that has yet to be seen, because we haven't had a claim yet. But that was our intention, is that we wanted to kind of cut that uncertainty and that lengthy and expensive process out of it.
All right, so Kristen in Colorado asks, I've never heard that before, that simple negligence is the default in a state that has an undefined standard of negligence. It's very interesting to me, as I have lots of conversations about liability with partners in Colorado. Are there any resources or citations you can recommend so I can look into that more?
Yeah, I would have to look into that specifically in Colorado, but so I don't have a citation for you in Colorado. But what I will say is the reason why it's the default is that in a general claim for tort, that is going to be your default standard unless something else applies. So if in Colorado there's been no court decision or statutory action, again, generally speaking, it should be that simple negligence would be the default.
I think, Jack, that answered your question as well, but if not, feel free to expand on that again on the Q&A. We also have a person who just wanted to confirm that everything we've been talking about applies to contractors burning slash piles as well. And they don't give their state, but.
There's currently, as far as I know, in any of the laws I've looked at, there's no distinction between slash piles or broadcast burning or the combination effort or some other mechanism for burning. Where you may run into distinctions is around what's the permitting required for that, and how do you show that you were exercising due diligence with respect to that particular activity. So if you can, you should check those specific requirements, but the general principles also apply to burning slash piles or burning, any other pile burning.
Right. Daniel asks, have you seen any examples of, in quotes, deep pockets approaches going after organizations that funded prescribed fires?
I have not seen it come to fruition, but I have seen threats. So that came up in California this past cycle, where I don't mean to harp on this smoke taint issue, but it really, like, it shut down a lot of burning in California, and it's sort of top of mind for me. But there was some cease and desist letters sent, which are not like an actual thing. It's just a title of a letter that someone could send to another person, where there were direct threats saying, essentially, we will go after the funders and the big organizations involved in the prescribed fire. So it's definitely, that threat is out there.
Yeah. Interesting.
Whether a funder who has no other role in the prescribed fire would actually be held liable is, I think, it's an open question, but I think fairly resolvable, because unless the funder is the one that is like selecting the burn boss or selecting the project or having a more direct role in the decision making, it is hard to see for me to see how they would be liable for the harm caused. Not to say that they couldn't be brought into a lawsuit, but that I think it would be unlikely for a court to establish that the mere act of funding prescribed fire is a negligent act.
All right, we have a couple of questions asking about how often or a rough percentage a case ends up in criminal versus civil courts, and how much case law do we really have around that, and where would we find, is there a repository of that case law out there?
So there's very little case law in this area, and my suspicions for this are couple-fold. One, there's a very low escape rate. You guys all know that. The escape rate is very low. So even if we do a lot of prescribed fire, very few are going to escape. When there's an escape, the likelihood that there are significant damages is also very low. So even when things either slop over or we have a need for suppression resources, we're often not causing significant amounts of harm. And then even beyond that, even if you cause harm, often things are covered by insurance. So an insurance claim would get worked out before litigation is ever filed, or there's a settlement either before litigation is filed or after litigation is filed, but before we get to a final reported decision. So like in California, we have one reported case. And that is, over 100 years of folks being able to do fire. So there's, I'm happy to send along some of the citations from other cases that I've pulled from, but just know that there's not a huge repository of case law out there. The instances of where I am aware of criminal liability, again, are in those either political or like really outside the scope of what you are all doing, where people are just, like saying they're doing prescribed fire, but it's not really that. And that it's kind of an after the fact of excuse for some really reckless or careless behavior.
Thank you. And Travis, I see you raised your hand. If you wouldn't mind putting your question in the Q&A, we'll do our best to get to it here. Thank you. Sara, we've had several questions asking about the definition of cultural burning and how that is different from prescribed fire or controlled burning by others.
Oh, good question. So I think that cultural burning is, let me put back up what the definition is that we came up with in California law a couple of years ago. So you can see it here in E. What I wish this definition had, because I think it is really critical, is a reference to tribal law, that it's burning done under tribal law, but that is not what we have. So what the key distinction here is that it's the application of fire to land by Native American tribes, tribal organizations, or cultural fire practitioners. So it's the who is doing it, makes it distinct from prescribed fire, and that it's to achieve cultural goals or objectives. And this means that tribes can engage in both cultural burning and prescribed fire. That the tribes can decide for themselves what they're calling it. And most of the tribes that I work with, what they hope for, or how they choose to describe it, is that cultural burning, again, is the things that are done under Indigenous knowledge, belief, practice systems. Prescribed fire is what they're doing under, where they've gone and gotten WCG certifications, or they've gone and decided to burn under BIA regulations or Forest Service regulations. And then that's prescribed fire with cultural objectives. So for me, I think it really turns on which law applies, but both which law applies and who is doing it. But this is the definition that California now has.
Semi-related, you just mentioned BIA. Can you clarify the caveat you mentioned about the FTCA not applying to discretionary activities / decisions by the government? And they go on to ask, are you saying that the FTCA doesn't apply to tribes burning under a BIA / 638 scenario?
Yeah. So to be clear, the FTCA applies to that scenario, BIA regulations, 638 compact. It applies to federal employees. The FTCA itself has this exception for discretionary activities. And what the exception means is that the federal government is not liable if either their employees or a tribe burning under those contexts, was exercising discretionary functions. And discretionary is distinct from ministerial. And what it means is that if you had to exercise judgment to choose how to do something, that's discretionary. If you were just told by your employee manual or your boss or a policy, this is the exact way you do it, then that's ministerial. So under the FTCA, most of the things that go into a prescribed fire, I think, should be categorized as discretionary, which means that the federal government would not be liable for harms caused by federal employees or tribes in the scenarios that the question referred to.
Mike asks, can you please expand on how a right to burn law might or might not strengthen or further enforce changes to liability law, and particularly a shift to gross negligence standards?
Yeah, so we don't have a right to burn law in California. So I'm making an assumption about what a right to burn law is. But in my mind, a right to burn law is a law that essentially says that a landowner has a right to apply fire to its land, and the government can't tell them no. Maybe the government could tell them, like, here are some conditions, but can't at the end of the day deny a permit. How I think that might intersect with a gross negligence standard is probably mostly a political question around if you're trying to work on a right to burn law. Are you also trying to bring that in a package together with a gross negligence standard, or is that a separate avenue? And I could see arguments, on the one hand, of trying to package everything together and just say, like, this is our pro-prescribed fire act, and like, if we enact all these changes, we're going to get more prescribed fire on the ground. But I could also see an argument against it where you say, we shouldn't be both giving landowners like unfettered rights to do this and then also making them not bear the consequences of their decision. So if that's the question, like, what's the strategy and should we bring these two things together? I think my answer would be to think carefully about it.
So we have a question here about where they might be able to find a generic waiver for burn participants, presumably something they might be able to tailor for their own organization. Are those out there?
Yeah, there are. So there's some examples on the California Prescribed Burn Association website, which I think is calpba.org. There's a couple of waivers there. I also think that TNC's waiver is Googleable. I think I have found it online before. So you might look for either the Trex waiver or another Nature Conservancy waiver, which are really strong. So those would be my two suggestions.
Right.
I will also say, because I am a lawyer and I have to, you should have a lawyer look at what you're doing. I've seen people attempt to modify waivers in ways that I'm like, oh, no, that didn't work. So exercise caution in adapting something you find online.
So I want to end on two questions that I think are really important. We're going to try to squeeze them in here before the top of the hour. In your experience, what is the most effective way for a state to work toward establishing a gross negligence standard?
Yeah. So it kind of ties back to what I said earlier about my like changing view that I think a claims fund is a better, more palatable route. And at least from my experience in California, if you want to work towards a gross negligence standard, I think you're going to have to figure out if the trial attorneys have a big presence in your state and have influence over your state legislature. And if they do, you're going to have to figure out how to work with them to get something done. I will say that the states that have done a gross negligence standard have all done them in conjunction with a certified burn boss program. Florida, the modern ones. So both Florida and Washington took that approach. So that sort of carrot stick approach of like, or maybe not carrot stick's not the right word, but this combined approach of saying like, we're going to make sure these people know how to put fire on the ground through a certification program, and only then will we give you the gross negligence standard. That might be a more palatable way to go.
All right, and last question. I think this is a great one for the end. How do I find expert prescribed burning policy / legal advice in my area? And what capacities or expertise am I looking for in a representative?
Good question. So I'll end by telling you a little bit of my backstory and getting into this work. So I came at this because I represented land trusts. So like the Nature Conservancy, but other regional land trusts doing land conservation. And a number of them wanted to do prescribed fire and approached me and said, hey, we're setting up Sonoma County's first prescribed burn association. Can you help us with that? And I told them, no, I don't know how to do that. Go find someone else. Then about a month later, I got another call saying, there is no one else, please help us. And I said, okay, if we can learn together and that you know that I'm coming at this as sort of new to this area. So what I would say, if you can't find someone that knows how to do this, find someone you like and try and convince them that this is a really cool area. If they want to call me, I'm happy to talk about that process, because it's been wonderful and I love working in this area now. In terms of the skills that competent legal counsel needs in this area, I think you're looking for someone that has a background in sort of organizational structure. So it's kind of like for lack of a better word, like corporate counsel, someone who understands how to manage risk for organizations. As well as someone who has an understanding around sort of natural resource management, permitting processes, that sort of thing. So I think both of those skill sets are helpful to find competent people. Yeah.
Wonderful, thank you. We have to leave it there, and I apologize we weren't able to get to all questions, but we will take a look at the remaining questions and maybe we can answer a few via email. Sara, I'd also love to pick your brain a little what resources we might be able to send along to everyone who registered, along with the recording of this webinar, that might help answer some of these more detailed questions as well. So. Wonderful. Well, thank you again, Sara. I learned a ton. Really appreciate your time and appreciate everybody attending today.
Yeah,
thank you.